Hi, everybody. Welcome. It's time for True Crime Wednesday. Hope everybody's doing well. Holy cow, do we have a lot to talk about? There has been stuff going on all day in Karen Reed. There's also been, hang on, I was just messing with my camera and then I looked all crooked. Anyway, there's been stuff going on and off all week on Delphi, which even though Richard Allen has been convicted and sentenced, there's still a lot to talk about on that case, as well as, hang on, I got to get myself organized here, as well as, oh my goodness, there is so much to talk about on Karen Reed. So I'm not going to do a lot of updates on a lot of other cases, but I don't know whether you've all heard or not, but Lori Vallow has decided to sit down with Keith Morrison from Dateline, and that is going to run on Friday. I'm sure the interviews took place a while back, but it's going to air on Friday. The timing is really weird. First of all, it's 3 weeks before her trial? Before her trial for Charles starts? It's crazy that she would want to further influence a jury pool, except that I think she just thinks that she is right and she can convince people that that she and Chad didn't do anything wrong. So, kind of crazy. The one little snippet that they have released is essentially her saying she and Chad are both going to be exonerated. And when he asks her, how do you know that? She says, because when I was in heaven talking to Jesus, he showed me visions of Chad and I in the future, and we weren't in jail. So, okay. I wouldn't hold my breath, Lori, if I were you. But it does make me wonder a little bit, or make me speculate, I guess, about what was going on with her lawyers. Because as you may recall, she recently asked to represent herself, and her lawyers have been acting as advisory counsel for her. And at the time, we all wondered why that was going on. Well, it may very well be that her lawyers told her this is a really bad idea, and she went ahead with it anyway. Now, we don't know, because people don't talk about whether or not they are compensated for their appearances. Now, we know that both Idaho and Arizona have Son of Sam Slayer laws that say that you can't profit from your crimes. So the timing is interesting when it comes to Arizona because she hasn't been convicted yet. So it's possible she's in Arizona, she's doing the interview in Arizona, and any gain that she would get would come to her in Arizona, and she hasn't been convicted in Arizona. And most of the Slayer laws require conviction. They don't operate pretrial. So it may be that she's made a deal with them. Who knows? I don't know that it's going to do her a lot of good in jail, other than she's going to be able to max out her commissary at $40 a month or whatever it is. $40 a week, maybe. I don't remember. But it's not like she's going to be able to really enjoy the possibility of ill-gotten gains if she was paid for it. So I am curious to know whether folks are planning to watch it or not. So I think a little bit later on, we'll ask that question and have you put your answers in the chat. So, but I did want to give you a quick update since we're talking kind of at length about Massachusetts cases. I did want to give you a quick update on Brian Walshe. My notes say more Massachusetts shenanigans. There was a court hearing on the 27th, and really interesting. If you recall, Bodie Laboratories is the company who came up with the proprietary processes to test hair that doesn't have a root. So hair that doesn't have skin cells attached to it. And you may recall that the hairs that were found on JJ actually were submitted to Bodie Lab for their processing. So in the Walshe case, Bodie Lab has been engaged to test some DNA tests for the Walshe case. And so the defense asked that there be an expert, their expert, be able to go and observe the testing that's done at Bodie Labs. So that's not unusual, and it's particularly not unusual if there's a possibility that the sample can be consumed completely by doing the testing. So if there's not enough of a sample to replicate the testing, and it may only be that they get a single shot at the testing, they may want their own expert to come and observe. So they need to coordinate the defense expert and Bodie. Now there's a bit of a problem with Bodie because Bodie said that they're in the middle of redesigning the space that they use when they have a visiting expert come and observe. It's getting more and more common, particularly in the case of labs like Bodie, where they're doing a process that only they do. So they're trying to keep the trial on track for October, but the timing is a little bit worrying because they are not sure that the observation suite at Bodie is going to be ready in time. So, and now on to Karen Reed, because this is going to take most of our time together today. It is complicated, and I'm going to try and put it into lay terms as well as I can. So we're going to start with information about the ARCA experts, because that argument is still going on, and Judge Cannoni has not yet rendered an opinion. She has said that she is going to, she was taking it under advisement and was going to render an opinion. So what this all boiled down to was not really a challenge that the ARCA experts weren't reliable, that their decisions or their findings weren't something that could be relied upon. Yes, I got my hair cut and I got new bangs and I'm still getting used to them and they're hanging in my eye. What the ARCA expert, what the crux of the argument was that the state was making, or the Commonwealth was making, is that there was some communication between ARCA and the defense that wasn't turned over. And they allege that the defense misrepresented to the court when they said, we have not had any contact with the ARCA experts. We didn't engage them. We haven't talked to them about their findings. They're going to come and testify to the substance of their report. That is still the case for this upcoming trial as well. So there's still this sort of pushing back and forth about whether or not there were full disclosures and whether or not someone made misrepresentations to the court. So the state is alleging, the Commonwealth is alleging that the defense made misrepresentations to the judge. That is a much bigger deal when we get on to some of the other, to the motion to dismiss. But they also, the judge also heard some other complaints about and some other opposition to some of the Commonwealth's other experts. First, there is a dog behavioralist named Dr. Crosby, and the state wants to call him to counter Dr. Russell's testimony about the dog bites or the potential dog bites. He is not a medical doctor, not a veterinarian, not even a forensic odontologist, which is teeth, forensic teeth. He is a dog behavioralist. And so they went through his qualifications. And as the defense pointed out, as the defense very clearly pointed out, the court during the trial would not let the ARCA expert, who is a biomechanical engineer, opine about the cause of John O'Keefe's injuries because he's not a doctor. There are a couple of series on television that are, the producers always have a little tag at the end where the guy says, not a doctor. Most notably, it's at the end of Brooklyn Nine-Nine. Anyway, he's not a doctor. So, the judge ruled during the trial that one of the ARCA experts could not opine about the causation of John O'Keefe's injuries because he was not a medical doctor. And likewise, this guy is not a medical doctor, unlike Dr. Russell, who is a medical doctor. So the subject is the medical cause of the injuries to John O'Keefe's arm. And this guy is not qualified. So the judge didn't decide, but I suspect she may not let him testify. The next one was a challenge against a witness who is a local weatherman. He's a meteorologist on the local news. And the Commonwealth wants to call him to testify that the ground that night was hard as a rock. Well, he's a meteorologist. He's not an expert on soil, not an expert hydrologist, not a lot of things. And so they've challenged him as well. I don't know whether the judge is going to allow him or not, but they made a good argument about it. So probably the two most explosive motions came from the defense. The first one was a motion for sanctions because of jury tampering. And what the defense alleges is that Trooper Fanning, who is a state trooper, tampered with the jury. Now, the way they say that is that they were called to a sidebar, which the sidebars we can't hear, but there were transcripts of this sidebar that were kind of bandied about in the argument. So we did get a little bit, but they were called to a sidebar because the judge advised them that there was a report that there was a juror, one of the jurors, had been overheard in a bar over the weekend talking about the case and talking about her opinions of the case. Now, no one knows who overheard this woman. No one knows how they know this information. And nobody was provided with any sort of information that would have been more concrete than that. It was like hearsay within hearsay within hearsay. So Alan Jackson asked that the judge call in the people who were alleging they'd heard this juror make these comments and get them on the record. And the judge wouldn't do it, but she discharged that juror just before Ellen Jackson's closing argument. And this was a juror that clearly was defense friendly. And so Ellen Jackson's argument is that they wanted to find out more information about who reported it and what the actual misconduct was, and the judge denied them the opportunity. But at the sidebar, McLaughlin, who I can't remember her first name, she's Brennan's co-counsel from the DA's office, said that it was Trooper Fanning who had brought the information to them. Well, Fanning was involved in the investigation of Karen Reed and actually went to her house and asked for her telephone. One of the ways that he was involved is that he was involved in the investigation into the witness tampering allegations that came about with Aiden Carney, the guy they call Turtle Boy. So Trooper Fanning was also the guy who was involved in the investigation into Sandra Birchmore's death, and was also involved in, was the one who cleared Matthew Farwell initially of her death. So he's right up there with Proctor in terms of his having his finger in a lot of investigations that are suspect. The judge took a real umbrage with their characterization of there being some sort of juror misconduct, and they had sort of a heated discussion about it. No one is alleging that the court security members, who the actual court deputies, did anything improper. This all has to do with somebody overhearing something and Fanning being involved in the investigation. So once again, she sort of took that under advisement. I think that one goes, I think it's a nothing burger. I think it goes nowhere. And all it did was serve to rile up Queen Bev, Judge Canoni. So, but the really big motion today was the motion to dismiss. So we've heard bits and pieces of their argument, of the defense's argument, as they've gone forward, as they filed motions trying to get all of this Sallyport video. But this is the first time we have really heard this laid out in a timeline. So, and I'm here to tell you that my head just about exploded. And I'm sure I watched Melanie Little's live stream. If you really want to see what happened, I highly recommend hers. But I'm sure Bob Motta and Andrea Burkhart, and I'm sure that they all were like over it. So let me just sort of walk through the timeline. So back at the very beginning of the case, 2 or 3 days after the incident happened, David Yannetti, who is Karen Reed's Massachusetts lawyer, filed a motion with the court and was granted an order preserving all of the evidence. Now, that is a pretty standard move for a defense attorney. You send out a blanket discovery request to the state and you file a motion requiring the state and all of its actors to preserve any evidence on the case. It's kind of standard practice. So Yannetti filed that. When he filed it, the case was still being heard by the district court. Now, we've seen this in other jurisdictions, such as the Vallow case, where we had a magistrate who heard the initial indictments, the initial arraignment, and the initial bond request. And so something similar happened in the Reed case. So the Stoughton District Court, no, not Stoughton. The town that Karen lived in, and where her car was impounded. Sorry, I have too many names buzzing around in my head right at the moment. They went to the district court and filed a motion asking to preserve all the evidence and asking and send a discovery request to the state. Now, even if they had not done that, the state has an affirmative obligation to preserve evidence and to turn over all evidence to the defense. So that's Brady versus Maryland, 1963. Been around a while. So even if they had not asked for that order, which the court issued, they would have, the state would have still had an affirmative obligation to preserve the evidence and to turn it all over to the defense. So it's kind of like a belt and suspenders. You're going to make double sure that you've protected your record, that you have asked for the evidence. So they did that right away. And then going all the way up to the trial, they had absolutely no idea that this Sallyport video existed. They had asked for all evidence. They had asked for videos. They had asked for stuff. They got videos that showed Karen Reed's car driving by the library, but there was no production of those Sallyport videos until a few days before her trial started last April. So they got one video that showed, that was the inverted video, okay? So they got this one inverted video that showed her car in the Sallyport flipped around the wrong way, with the video mirror image. So it looked like when all the police officers were standing around the back of her car, it appeared that they were standing next to the passenger side of the car. In fact, they were standing next to the driver's side of the car because it was inverted. And so in order to, and the state put that on to prove that nobody had been around the taillight in question. And in fact, it was misleading to the jury because they had been standing around the taillight in question. So they got that video maybe 2 or 3 days before the trial started. Now, the trial went on for 10 weeks. So during that period of time, the state then produced an additional video that showed Karen Reed's car on a flatbed trailer being brought into the police department. Now, let's remember that within less than 24 hours, the Canton Police Department was conflicted off of this case because they were investigating the death of a Boston cop at another Boston cop's home. And the home, the McCabe home, his brother was a Canton cop. So it was way too incestuous. So they were conflicted off of that case. In spite of the fact that they were conflicted off of investigating the case, Karen Reed's car was brought into the Canton Police Department's Sallyport, their garage, basically. The reason for that, supposedly was because the weather was terrible and it was the only place they could go that was undercover and heated. So during Karen Reed's trial, they got 2 videos. One was the reversed manipulated Sallyport video of her car nose into the Sallyport. And the other was her car being delivered on the flatbed truck. Neither one of those videos were great quality and conveniently got real blurry about the time that there were any decent shots of the taillight, which the police department claims was shattered and that they found all the broken pieces in front of the McCabe house. However, there is a police officer who was there when they impounded Karen Reed's car. Now, if you remember from the story, Karen Reed backed out of her driveway in a panic, still partly drunk, backed out of her driveway to go look for John O'Keefe, and backed into his car and she says, cracked her taillight. Now, when they impound her car at her parents' house a day or so later, what the officer who is in charge of collecting the car says is that that taillight was cracked but not shattered. There was a piece missing from it. Now, interestingly enough, when the officer came on the stand in her trial and put all of those pieces together that they supposedly collected from the O'Keefe death scene, there's one piece missing. Probably the piece that was missing when her car was impounded. The rest of the pieces are all there. So, kind of suspicious. So, they only had those 2 pieces of video. Now, we have a mistrial. We're getting ready for trial number 2. And as they're getting ready for trial number 2, they once again file a request to get all of the videos. Now, what they have asked for is for the 24-hour period that they want the Sallyport video for the 24-hour period that includes the time that her car was brought into the Sallyport. And they keep getting these they get these 2 pieces of short pieces of video from the first trial. So they file a motion. The other thing they want, because now they know that at least the video that they have was inverted. So now what they say is, we want the raw data, the metadata it's called. So it's the data in the background of every video that says when it was created, what platform was used to create it, how long it is, all of the minutia of what makes that video uniquely that video. And that's all in the background. So they want that data because that data will show whether or not that video was manipulated in any way. They want to be able to look at the raw data as it was filmed in the Sallyport, and they want their expert to look at that, because then they can tell, if they compare that to what they got, they can tell whether it was manipulated before or after, after the video was made. And so they asked for that. Nothing, crickets. They then ask if so there's all of this opposing information about the videos, right? So when Hank Brennan comes on the scene, he orders a complete review of all of the evidence in the Reed case. And lo and behold, one of this Christine, she's their IT guy, IT person. she goes down and looks at the server in the police station and says, oh, wow, well, yes, this system overwrites itself in 30 days, but there's also a backup storage. And these videos are actually on the backup storage. So then they go back and so then the defense says, okay, great. We want our expert to come and take them off that server. When they get to the Canton Police Department, lo and behold, they're gone. Nobody's got them anymore. Then they're told that there is this retired police officer, Canton police officer, who has them on some sort of storage device. At first it's in the cloud, and then maybe it's not. Maybe it's on a local storage device in the police department, and nobody can figure it out. So here's the part that is just absolutely stunning. What we learn as they make their presentations, someone knew that those videos existed. Now, early in this hearing, there was some conversation about whether Yannetti knew about something that Alan Jackson did. Now, remember, Alan Jackson is pro hac vice. He is admitted to the bar for the purpose of representing Karen Reed. He's a California lawyer. Yannetti is the Massachusetts lawyer. And when you admit somebody pro hac vice, you do it with someone who is their supervisor, who is their sponsor to come into the state bar. So in this case, Yannetti is kind of on the hook for anything anybody else does. So that's not the case when it comes to ethical violations. It is the case when it comes to Rule 14 obligation to produce discovery. So the judge said to Yannetti, you understand that what one of your team knows, all of your team knows. That's the way the law works for Rule 14, for discovery violations. If one of your team knows, the law presumes they all know. That is also the case for the Commonwealth. And that extends beyond the prosecution to law enforcement. So if law enforcement possesses a piece of evidence or they know about a piece of evidence, the prosecution is presumed to know about that evidence as well. So just like if one attorney knows, it's attributed to all. If law enforcement knows, it's imputed, the knowledge is imputed to all of law enforcement, including the prosecutors, who are considered law enforcement. Prosecutors all carry badges. Here's the other piece of it. If bad faith can be shown, which means that the withholding of the evidence was intentional, okay? It is presumed that there is prejudice. So the way that the law works, the test is, if you are denied discovery, the first thing you have to ask is it exculpatory? And exculpatory is very broadly construed to include, does it, and we're going to talk about this when we get to Delphi later, is it likely to produce information favorable to the defense? So you can bridge the gap a little bit more than it has to be. It does not have to prove that the defendant is innocent. It has to be favorable to the defense or produce information that could be favorable to the defense. So it's pretty broad. So if you are saying a discovery, we didn't get this information, it's a discovery violation, and we were prejudiced by it, one of two things has to happen. Either you have to prove that it was intentional, or you have to prove that it was inadvertent and that the defendant was prejudiced by it not being turned over. So what they're saying, what the defense is saying, is we went on both of those because clearly this was intentionally withholding discovery, and she was prejudiced by it. Even if you find that it was inadvertent, she still was prejudiced by it because they had information we didn't have when we were doing our cross-examination. So here's the part that just bowled over everybody. So in preparation for this hearing, there were reports just written. Now you'll remember there was a hearing where last week where Yannetti was one of the defense attorneys. They filed a motion wanting a chain of custody for those videos. They wanted to know who handled them, when they handled them, and usually every piece of evidence has a chain of custody log that goes with the evidence. Nothing. So they asked for a chain of custody, and they said, well, we can't recreate, we shouldn't have to recreate what we don't have. And the judge looked at Little, the defense attorney, and said, Ms. Little, you're not expecting them to create something they don't have. Now, miraculously enough, that was exactly what they were doing, was they were going back and trying to cover their butts having to do with this, with the chain of custody of the logs. So lo and behold, 2 days before this hearing, suddenly they get new police reports and new affidavits from people. New police reports. Here is the gobsmacker. On the 22nd of February, oh no, in February of 2022, I'm sorry, days after the incident, Trooper Proctor, Michael Proctor, requested the Sallyport exterior, so it was before the overwrite. He requested that this, I cannot figure out this guy's last name. It's D. Daradello or something. It's a very complicated, probably Italian name, but he's the retired Canton cop, and he was in charge of the video system. So Trooper Proctor requests in February of 2022, before that 30-day overwrite period had come, that officer download all of the videos, which he files a new police report a day or two ago that says, I downloaded all those videos, and they were so voluminous that I had to download them in 6-hour increments. And I downloaded them, I put them on a storage device, and I told them I had them. Now, dun, 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 here comes Trooper Buchanan. He's also Massachusetts State Police. He goes by the Canton Police Department, picks up the storage device, drives it over to the district attorney's office, and drops it off. Let that sink in. Okay. So in February of 2022, the district attorney's office has the complete videos, the complete 24 hour download of all those videos. Then in June of 2023, which is before the trial, Proctor, but it's right around the time that the federal grand jury is meeting, Proctor once again calls Canton Police and has this now retired officer download those videos. He puts them on a CD, and once again, Buchanan goes by the Canton Police Department, picks up that CD, and delivers it to Michael Proctor. So at a minimum, Michael Proctor had those videos since June of 2023. But nothing is produced before April of 2024 when Karen Reed's trial starts. Now, to make it worse, the police chief, the Canton police chief, is strategizing with them about how to present these videos. So she knows they exist. However, they have never been produced to the defense. The defense does not know they exist. So, twice, these were provided to Proctor. And twice, even though Proctor knew that the defense wanted them and knew that they had an obligation to turn them over, they had all of those videos that the defense wanted and should have gotten and never turned them over. The defense never got them. So Karen Reed goes to trial. We have a mistrial, and we're getting ready now for trial again. They still have not turned over all of that video material, all 24 hours. But recently, out of nowhere, they drop a video that shows Karen Reed's car being backed into the Sallyport, which gives you an entirely different angle on the taillight. But miraculously enough, the area of the video where taillight can be seen is too blurry to make out what the condition of the taillight is. So Alan Jackson makes the point, either because they exist, either they downloaded it before the 30-day overwrite period ended, or it didn't overwrite. Regardless, so during the trial, the police chief is talking to the prosecution and to Buchanan about the video and about how they're going to counter the video. And it was video that this was during the trial, and was video that they didn't have. So Alan Jackson gets up. If you have an opportunity to watch the video, and Melanie Little does a great job. She's got, sort of a running outraged commentary on it if you're interested. And throughout that whole time, Alan Jackson makes this very cogent, very well-reasoned argument, lays it all out, and finishes up by saying this case needs to be dismissed based on these egregious discovery violations. And he's right. So Brennan gets up and does what every prosecutor does. He stands up and says, it wasn't really relevant and we weren't going to use it. Now, why every prosecutor thinks that this is an excuse for them not to produce discovery, it absolutely mystifies me. let's be clear about the law. The law says, Brady says, you absolutely must turn over every piece of evidence to the defense. The prosecution doesn't get to decide what's relevant. They don't get to decide whether it goes to their case. They don't get to decide that. It is not for them to decide. Now, I remember in the Vallow case, we had quite a few dust-ups between, I keep sliding down on my chair, sorry. We had quite a few dust-ups between the defense, particularly John Pryor, and the prosecution. And John Pryor kept saying, I want that discovery. You remember, they said there had been a bunch of FBI interviews and they hadn't turned them over to the defense. And they kept saying, well, we didn't think they were important. We didn't think they were relevant. And John Pryor kept saying, that's not for you to decide. You are not the gatekeeper. The prosecution is not the decision maker of what's relevant or what needs to be turned over. Just because the prosecution doesn't think that the information supports their theory of the case doesn't make it irrelevant. Case in point. I am absolutely sure that they would have produced the discovery, those videos, if the videos had clearly shown that Karen Reed's taillight was shattered, because that would have helped their case. That would have helped their theory of the case, which is that Karen Reed backed over John O'Keefe in front of the McCabe's house and left him to die in the snow. If it had been inculpatory, they would have used it and they would have produced it, guaranteed. But they're going to stand up and say, well, we didn't, and they're also saying, the prosecution saying, well, we didn't know that it was out there because Proctor didn't give it to us, which is bullshit. Excuse me, but I'm fired up about this. Because Trooper Buchnick says the first time he got a download of those videos, he took it to the DA's office. So the DA had it. If they didn't find it in their file, that's on them. They had it. So there's no excuse for them not turning it over. But them standing up and saying, well, we didn't know about it, and it wasn't really important anyway because it wasn't really relevant, and it wasn't really relevant to what we thought the defense's theory of the case was. That's not the point. The theory of the case changes over time, particularly the defense's theory of the case, as they get more information. We saw that in Delphi. Had the defense had the information about the potential of other third-party culprits that came out after trial, they might have approached their case differently and they might have shifted their theory of the case. Okay? So Brennan says, well, and that whiny little weaselly voice of his, the defense theory didn't make it clear to them that the video was important, and they didn't get a motion from them asking specifically for video of the Sallyport. Now here is the frustrating thing. The prosecution gets everything. They have the power of the state. They can send cops out to scour. They could send a team of 50 men, 50 police officers out to scour the McCabe yard. And they could do that every day for a month because they have the resources to do that. The defense doesn't have the resources to figure out what's in the prosecution's pocket. Okay, this isn't a riddle under the mountain with the Hobbit. You don't have to guess what's in the prosecution's pocket. They're obligated to turn out their pockets and show you what they have. There is no obligation for the defense to ask, like Gollum, can I have that ring in your pocket? You don't know what you don't know. And because of that, because the defense can't know what they don't know, so they don't know to ask for what they don't have, because of that, the state has this affirmative obligation, which attaches at the moment that someone is charged in a case, that goes above and beyond any request the defense makes, any preservation orders that the judge orders, any of those things. It goes far beyond that. They have an obligation, constitutional and statutory obligation, to preserve evidence and to turn it over. And they didn't do it. So essentially what is happening is the Commonwealth is now throwing Michael Proctor under the bus, and probably Buchanan as well. And I suppose from their standpoint, it makes a certain amount of sense. He's already damaged goods. They have already shown that he is a repulsive, dishonest cop. He's already under that black cloud that from last trial, from looking for nudes on Karen Reed's photo, in Karen Reed's photos, to calling her names, to very clearly going after her. She was their prime suspect from day one. I mean, he's just a repulsive human, and he's very likely going to get fired. So it makes a certain amount of sense for the Commonwealth to throw him under the bus because he's already damaged goods. It's very unlikely that the Commonwealth is going to call Proctor. The defense would be foolish not to call him. So I'm sure that he will get a thorough grilling in the new trial, if there is a trial. So they go on to kind of blame it all on Proctor, that Proctor was the one who had all the videos, that they didn't know that there were these videos, and as soon as they knew, they turned them over. And they said that there wasn't any intent to use the video. This is what the Commonwealth said. Well, we didn't intend to use it, so we just thought it was no big deal. Well, of course they didn't. So there is a rule, and it came out today. There is a rule that says that one of the punishments for not turning over discovery is to say to somebody, you can't use it. Well, that is not helpful to the defense when when what they have failed to turn over is exculpatory, because the defense doesn't want that kept out. They want the exculpatory information to come in. So the exclusionary rule, as the judge, as it's called, and the judge referenced it earlier, doesn't help the defense. It doesn't compensate the defense for what's happened. So it's not really a remedy for them. So after the trial, Colleen Crawford, she's the IT person, went to Canton PD to look at the DVR and realized that there was video saved on backup hard drives. It was she said it was there. And then when they sent their expert down to get it, miraculously, it was gone. The other problem from early on was that the reason they wanted their expert to come and get that information was they were told that the sheriff who had been downloading and saving this stuff was simply clicking and dragging it to another file, and that destroys the metadata because it overwrites the metadata with new information about the new the new filing. And so they wanted it in its original raw form. And they kept saying, well, we'll video somebody clicking and dragging it to show you that we did it right. And Alan Jackson kept saying, no, we don't want you to do that because we don't want the metadata to be destroyed. And lo and behold, that's what they did. So the metadata is now gone. They asked Judge Cannoni to preserve it, and she denied their motion. Why? I don't know, but she denied the motion. Then it comes out that the chief of police was with the IT people downloading these videos during the trial. But they've recently, the disciplinary board for the police has recently cleared her of all wrongdoing. So here's the point. Brennan says there's no evidence that that any of these videos were tampered with, but there's no evidence that they weren't tampered with either because the metadata has been destroyed. So here's one thing that Hank Brennan said that just absolutely floored me. He said, if the government was looking to hide it, it would have never, they would have never gotten it. Really? So he says their claim is baseless because there was no bad faith. But Proctor did hide it. So the argument goes, Proctor is a law enforcement actor. His actions are imputed to all of the law enforcement, including the district attorney. So even if you overlook the fact that Buchanan says he delivered a thumb drive or a storage device in February of 2022 to the DA's office, even if you overlook that, Proctor is still considered part of the prosecution team, and his knowledge about the evidence is imputed to the state. So they're on the hook. I think that they made a really compelling argument for dismissal. I think there is a possibility that they have backed, for lack of a better description, backed Judge Cannoni into a corner. I think that there's a possibility that she doesn't have any other choice but to find that the Commonwealth violated Karen Reed's constitutional rights and that the only remedy is dismissal. Judge Cannoni is a very prosecutor-heavy judge. That's not unusual. Most judges lean towards the prosecution. In a lot of cases, it's because they were prosecutors. And we have seen some pretty troubling bias from her. However, she is not really in a position to, she can only go so far in that before her reputation gets destroyed. It's one thing to decide something that is within the judge's discretion. And when the appellate court standard is whether or not the trial judge abused their discretion, and they have very wide discretion, that's tough. And it is one thing to make rulings and have people contest your discretion and say maybe this was an abuse of discretion. It's another to be seen as a judge who's making patently unfair rulings that are clearly an abuse of your discretion. So I think that the defense team has now put enough evidence in front of Judge Cannone. So here's the next thing. Judge Cannone could decide this based on what she heard today. Or she could say, I want a full evidentiary hearing. I want Sergeant Buchanan to come in and testify. I want to hear from the IT person. I want to hear, I want all these people to come in and testify under oath, and we're going to gather evidence. We're going to have an evidentiary hearing. And that's ideally if she does not outright dismiss the case. That's what needs to happen, because the defense needs a record so that they can appeal as part of their appeal of what may be the next conviction. So she has a choice. She can either dismiss based on what she's heard, she can deny their motion based on what she's heard, or she can order an evidentiary hearing. I think she's going to be hard pressed to dismiss this without an evidentiary hearing. If I had to guess, I think that she is not committed enough to favoring the prosecution to outright deny the motion with this much evidence behind her, behind them. I think she is going to order an evidentiary hearing. That way, she has cover, regardless of which way it goes. Regardless of what comes out at the evidentiary hearing, I think that provides her with some cover. If she denies their motion following the evidentiary hearing, then the defense has a full record to appeal on, and this is not something that can be appealed on an interlocutory basis. So an interlocutory appeal is one that happens before trial or during trial, where a judge's order can be appealed and the trial gets stayed until the appeals court makes a decision. That is not the case. This is not one of those kinds of findings or orders. So I think she's going to order an evidentiary hearing, and I think we're going to get it. I think she still wants to keep that April 1st date on, although I don't know if that's going to be possible, because I think an evidentiary hearing may turn out to be kind of a mini trial. It could go on for a week. So it would not at all surprise me at this point for her to schedule an evidentiary hearing and to bump the trial out. We'll see how my crystal ball is. But it was sort of interesting because, and this is a case I have not followed. I know that there are other people out there who've really followed these parallel cases to Karen Read. So all along, there has been a large population of people who have been in support of Karen Read, think she's innocent, and they've been demonstrating on the streets. There have also been a group of people who think that she's guilty, and they've been demonstrating on the streets. And there are quite a few different creators who have different opinions about whether or not she's guilty. There's one particular creator, and he's a local guy. His name is Aidan Carney, spelled Kearney, pronounces it Carney. And he's a local creator and calls himself a journalist. He's been covering the case since the very beginning. He believes that Karen Reed is being framed and that she's the victim of a lot of institutional corruption in the Boston area. And he has been investigated a couple of different times and charged a couple of different times with witness intimidation and witness tampering for confronting witnesses. There were a couple of confrontations on the street, one outside a bar. I don't know that much about it, other than that it's sort of peripheral to Karen Reed's trial. At one point, he apparently had some contact with Karen Reed, and so now there's also allegations that they were in cahoots to interfere with witnesses. He had a hearing today. So his hearing was in the same courthouse, and Betterow, who is a New York attorney and who is representing Aidan Carney and is their pro hac vice. He's also an attorney that Karen Reed's team has tried to bring in pro hac vice, and he has not been yet admitted because the state's raised some questions about whether or not there's a conflict, because there are allegations that Aidan Carney had contact with Karen Reed and that they conspired to intimidate witnesses, supposedly. So I just heard today, saw a little snippet. Well, the thing that happened was Melanie Little was going to cover that Aidan Carney hearing after Karen Reed's hearing was over, and they kind of overlapped. But what we heard was that it was done on a Zoom, and they muted the Zoom so that if you weren't in the courtroom, you couldn't hear what was going on. And they just charged him with something new. I'm not even sure if I know what those new charges. I don't know what those new charges are yet. There was another guy in town who went around and distributed rubber ducks, and they had a little tag on the bottom that said Colin did it. Colin is the McCabe's son, I think, or I can't remember, but Albert, he's Colin Albert, so he's the McCabe's nephew. Apparently there was some bad blood between he and John O'Keefe. So this just citizen went around and distributed these rubber ducks around town, and he was charged with witness intimidation. Those charges have since been dropped, but the rubber duck has sort of come to signify the whole Karen Reed foolishness. So it's been really, really crazy. I've never seen anything like this, and I don't think anybody else on LawTube has either. It's crazy, and it just gets crazier and more convoluted. And the Boston law enforcement and the prosecutor's office there just comes off continuously looking, Carroll County looks bad. They all look bad. So I want to shift to Delphi because there's a similar thing going on in Delphi. So let's talk a little bit about Delphi and all the players. So Richard Allen was convicted, sentenced to 120 years. His attorneys are now doing the post-trial motions. So post-trial, there are always motions that need to be filed in order to preserve them as part of the appellate record. So one of the post-trial motions is a motion for a new trial, or in their case, they call it a motion to correct the record and to fix things in the record. And they also file it because of potentially new evidence. Okay. So they filed their motion, judge denied it. And then they discover that there is new information that they didn't have when the trial happened. So the way it starts out is there is a guy in prison, and his name is Ricci, R-I-C-C-I, Davis. So Ricci Davis. Now, everybody knew about Ricci Davis. Ricci Davis had there was a statement out there having to do with Ricci Davis that was sort of buried in all of the discovery that was given to the defense. It didn't really seem at that point like it was anything, but everybody knew it was out there. So post-trial, at trial, the medical examiner that did the autopsy opines for the first time that the girls were killed with a box cutter or some sort of similar knife. And this is the first time the defense has heard any of this. Prior to that, the medical examiner had been saying it was two knives. One was serrated. And it wasn't until just before the trial that he said he was standing at his workbench and he had a box cutter in his hand, and he looked at it and realized that that was the imprint that he was seeing in the skin of the murdered girls. So he changed his opinion literally on the stand. So as the defense is going through their process of their post-trial motions, one of the things they discover is a statement that Ricci Davis made that Ron Logan, who was the owner of the property the girls' bodies were found on, said the girls had been murdered with a box cutter. So if you remember, the judge denied all that they could bring in all of that third-party culprit evidence because she said there was no nexus. That's legal speak for no connection. So there has to be a connection between an evidentiary connection between the incident and the potential third party. It can't just be somebody pointing fingers. There has to be something more to connect that person to the crime. So this was the first time that there was really irrefutably a nexus. And that came out because the coroner changed his, or the medical examiner changed his testimony at the last minute. So, but in the process of this, they say, okay, well, maybe we really need to talk to this Ricci Davis guy again. So Andy Baldwin, who is the lead defense attorney, goes over to the prison where Ricci Davis is being held. He's there long-term on drug charges. And he asked to speak to him. So he sits down with Ricci Davis, and Ricci Davis tells him, you know, early on, I didn't want to talk too much to you or to anybody else, because they actually did go talk to Ricci Davis early on when they were investigating the case, and felt like they'd gotten what there was to talk about. He was pretty closed off, wasn't really interested in talking to them, but did tell them, I gave an interview, recorded interview to the police, go watch it. So they requested it, never got it. So Andy Baldwin, this is post-trial, goes out to the jail and sits down with Ricci Davis. And Ricci Davis says, well, there's a lot more to this story, and I know more than I knew way back then. He said, I was in jail with Ron Logan. Now, Ron Logan, who's the property owner of the property where the girls' bodies were found, died during COVID. So he's not around anymore. And he said, I talked to Ron Logan, and Ron Logan told me that he and two other people were responsible for the murders and that somebody used a box cutter. Okay. he said, I wasn't too thrilled to talk to you because I didn't know whether Richard Allen was one of those other two people. So I wasn't going to help you out. Said then I started talking to Keegan Kline. Now, Keegan Kline, early on in this case, was identified as a potential suspect. You might recall that Keegan Kline was a guy who was involved in distributing child essay material and photographs, etc. And he was suspected because when they found Libby's cell phone, there were Snapchat conversations with a guy named Alan Schatz, Andrew Schatz, can't remember. And the pictures were of this really jacked male model. Well, it turned out that Keegan Kline was using that persona to catfish girls, and particularly young girls. And so in the process of the investigating whether he was involved in the murders, they realized that he had been deeply involved in distributing and possessing and distributing child essay material. And so he was charged, unrelated to the Delphi murders, with possession of those materials. And he pled guilty and went to prison. So he's in prison. And he, according to Reese Davis, he finds out that Reese Davis had conversations with Ron Logan. And he's worried about what Ron Logan might have told him. So he starts up a conversation, or a series of conversations, with Reese Davis. What did Ron Logan tell you? And in the process, Keegan Kline then tells Reese Davis, it was Ron Logan and me and one other guy. And Reese Davis says, is the other guy Richard Allen? And Keegan Kline says, no. But he also gives a great deal of information that only someone who had committed the crime would know. And it's a lot of information. It's a lot of detail. It's a lot of who stood where, who had what kind of weapon, all of those kind of details. So Andy Baldwin, in the process of this conversation that he has with Reese Davis tells him, I wrote letters that I sent to the prosecutor telling them about this stuff that I heard from Ron Logan and Keegan Kline. Most recently from Keegan Kline. So he says, Reese Davis says, I think I wrote about 8 letters. At least one of them was during the trial. So Andy Baldwin goes back to his office that very night, emails Nick McClelland, who's the prosecutor, and says, what about these 8 letters from Reese Davis? Do you have them? Doesn't hear anything. So he follows back up with him and says, my understanding is there's a video and 8 letters, and I want them. And Nick McClelland's answer is, the trial's over, you get bupkis. So now Andy Baldwin decides that the only way he's going to get that information is if he files a motion with the court. So he files a motion with the court asking the court to preserve any letters from Reese Davis and any video interviews of Reese Davis. And he puts it in writing. Well, now McClelland is mad because now all this stuff is getting out into the public. Now, remember, the gag order was gone once the trial was over and Richard Allen was sentenced. So there's no gag order anymore. So now McClelland's mad. So McClelland files this quite insulting reply. And Baldwin essentially goes through what Reese now he acknowledges he does not know whether anything Reese Davis told him is true. But just like we saw in Karen Reed, the prosecution had an affirmative duty to turn those letters over to the defense. Because even though they may not have had any evidentiary value in themselves, they may have turned up information that the defense would want to follow up on, take depositions, do all those things. Because in Illinois, they allow witness depositions in criminal cases. Or, I mean, that's in Indiana. Not every state does. So Nick McClelland says, oh, no harm, no foul. Andy Baldwin says, I don't know whether all this stuff that Reese Davis said is true, but I know that we didn't get it and we're entitled to it, and I want it preserved in case Richard Allen gets a new trial. And he lays it all out. He lays out what Reese Davis told him, and he lays it all out and lays out that he attempted to contact Nick McClelland, and McClelland wasn't cooperative, and he puts it all in a motion. This is good lawyering. This is exactly what lawyers do, is when in doubt, get it in the record, get it in writing, because it can't be considered on appeal if it wasn't raised. So this is good lawyering on their part. However, so now Nick McClelland fires back an answer. So I'm actually going to read bits of this. I don't always read to you. And in order to do that, I have to turn over here to my screen. So forgive me if I'm I'm sorry. For some reason, my microphone muted, and I don't know why, but you got me now? Okay. Thank you, Jen. So to back up a little bit, the Nick McClelland's position is discovery is evidence in a case that the state intends to use at trial, or evidence that tends to exonerate the defendant, referred to as exculpatory evidence. That's absolutely not true. But why all prosecutors seem to take this position, I don't know. But it's not true, because what Brady says is information favorable to the defense. Now, there's no question that even if Reese Davis's statements don't exonerate Richard Allen, they could potentially have contained information that could be favorable to him. Different, very different definition. But this is what he says. Not all information gathered in an investigation is discovery. Well, I heartily disagree. Most of what Reese Davis told attorney Andrew Baldwin is false. Well, we only have Nick McClelland's word on that. We don't have any way to tell that. He says Andy Baldwin had an opportunity to fact check, in quotes, the information Reese Davis provided to him, but instead chose to put the information in a public motion without verifying its truthfulness. So it says the state contacted the Department of Corrections and had the department send a list of all outgoing mail from Reese Davis to the Carroll County Prosecutor's Office, attached here as Exhibit 1. So, as the court can see from the list, Reese Davis did not send the state 8 letters. He only sent 3 letters. 1 letter on October 4th of 2025, 1 letter on October 15th of 2025, and 1 letter on October 21st of 2024. That's what this says. I don't know. Oh, but this says all during or very near the trial of State of Indiana versus Richard Allen. So since October of 2025 hasn't happened yet, I'm assuming that that's a mistake and that should all be in October of 2024. The state was able to recover 2 of the 3 letters Reese Davis sent from Reese Davis, and they are attached to this motion. The letters sent by Reese Davis are not exculpatory for Richard Allen and therefore not evidence or discovery. The letters, in fact, accuse Richard Allen of committing the murders. It's not exculpatory evidence, which I patently disagree with their definition of what discovery is. Additionally, Reese Davis in the letter, one of the letters says that he's attached a note that Keegan Klein wrote. That's not included in here. It says the letter goes on to implicate Richard Allen in the murders, stating that he set up the meeting with the girls. He's the one that killed the youngest girl, and that once the girls were killed, he's the one who moved their bodies. In the other letter, he states that Ron Logan, Keegan Klein, and Richard Allen are responsible for the murders. He goes on to say that Andy Baldwin is an ignorant lawyer who was hinting me to lie for him and his client, saying that I should know how it is. That although the state has diligently searched all the evidence involved in this case, the state cannot locate or even verify that the second letter sent from Reese Davis was received by this office. James Winters, this is Keegan Klein's father or uncle, I can't remember, did call the Reese Davis's, it's a relative of Reese Davis's, did call the prosecutor's office on October 15th and near October 21st to verify that this office received the letters sent by Reese Davis. However, at that time, he did not indicate how many letters had been sent. He indicated that both Keegan Klein and Reese Davis had been subpoenaed by the defense to testify at trial against Richard Allen. Now, I don't know how that could be. If they were subpoenaed to testify against Richard Allen, it would have been by the state, so McClellan would have known that. I think at one point they were on witness lists from the defense because the defense was still trying to get their third-party culprit information in. So then it goes on to say the state finds the information Reese Davis supplied is not credible. Well, I don't think Andy Baldwin ever claimed that all of the information. Can you all hear me? Okay, thanks. I just got a text from my husband saying no sound, so he's a little bit behind though. He usually is a few minutes behind. So there's zero evidence found in the investigation that Ron Logan and Keegan Kline knew each other or shared or exchanged child images. That the state was able to obtain recent communication between Keegan Kline and various civilians where Keegan Kline denies the allegations set up by Reese Davis. Well, of course he would. He's not going to admit it. He says he was, according to Reese Davis, he says he was relieved when Richard Allen was arrested because he was off the hook. So Keegan Kline says Reese Davis is an idiot. I've only talked to him maybe 2 times. He's one of those guys in prison that tries to write all different prosecutors and get time cuts on people's cases. It's laughable, and reiterates this point in several of the responses he texts. So essentially, Nick McClelland spends a lot of time discrediting Reese Davis and discrediting Andy Baldwin. And he says Reese Davis's statements to Attorney Baldwin don't match the statements he made in the letters he sent to the state. Now, it is, regardless of what those letters say, the defense had a right to have them, and they were withheld. So once again, we get to the whole issue of discovery violations. And this is a pretty serious discovery violation. So do I think Judge Gold's going to do anything with it? Absolutely not. She's not going to do anything with it. That case is done, and she's out of there. But it's important that the defense is making their record for the appeal. Now, everything I've heard from Andy Baldwin, what's in his documents, everything I've heard him say is that he doesn't know whether this is true or not. He has never known, and there really may never be a way to find out whether it's true or not. But it goes to the point that they should have been able to bring this in at trial. First of all, it should have been turned over to them, and the fact that it wasn't is a Brady violation. And second, that they should have been able to bring in the third-party culprit testimony, because there was a sufficient nexus to raise reasonable doubt. So I think Judge Gull, unlike Reed, where I think there is a possibility that Judge Cannoni may be backed into a corner far enough that she may have to consider dismissal. At a minimum, she may have to give them the evidentiary hearing that they want. Unlike that, this trial's over, and Judge Gull has nothing to lose in just summarily denying all these motions, and I expect that she will. So the next thing that happened, however, is that then Andy Baldwin filed an answer, and it's pretty scathing. And I couldn't turn it up right away. But if you want to, trying to see if I could turn it up really quickly, but I don't see it. But if you want a full reading of it, Bob and Ali Mata did a full reading of it and actually had Andy Baldwin on to talk about it. And it's a really good episode. It's from maybe late last week. So I'll track it down and we'll add a link in our show notes as well. But it's he answers. And, Andy Baldwin keeps saying, I don't know whether this information is true. I don't know whether Reese Davis is the least bit credible. I mean, typically people who are in prison are not credible. But also inmates in prison talk. Sometimes it's the only thing they have to do in their lives is talk. They're worse than Real Housewives when it comes to gossip and backbiting and who's in and who's out. Prisons are little, very condensed societies, and sometimes gossip is the only thing you have to trade in a place like that. So it's not unusual for inmates to talk. It's not unusual for inmates to talk about their crimes, even though as lawyers, we're constantly telling them, presume you're being recorded every time you open your mouth. Don't talk, don't talk, don't talk. They do, because they're bored, because gossip is sort of a form of currency. So would it surprise me if Keegan Kline said those things? No. Would it surprise me if Reese Davis made it up? That wouldn't surprise me either. But the defense had a right to know that this information existed and to test it and to make their own decision about whether or not it was credible, whether or not it was something that they needed to pursue, whether or not it was something that they were going to attempt to admit at trial. They had the right to know that and to make that decision for themselves. When the prosecution decides what's relevant and what's not, then we run into trouble, because it's now the prosecution deciding what the finder of fact gets to hear. And that's wrong. The way that our justice system works is when we have a complete and rigorous airing of all the facts. And you can't do that if you don't have all the facts, if the defense is swinging with one arm tied behind their back. The prosecution always has all of the advantages, and that's a problem. So we find ourselves once again in a very lopsided situation. Because the prosecution has all the cards, they have all the power, they have all the resources, and the defense is always at a disadvantage because they don't know what they don't know. Andy Baldwin didn't know that there were letters out there that Reese Davis had written to the prosecution around the time of the trial. Andy Baldwin asked for and didn't get a recorded interview that Reese Davis did with law enforcement. So he had no ability to look at that and assess whether or not that was helpful or hurt his case. And but he had the right to do that. It was not the state's right to make the decision whether it was relevant, whether he got it or not. It's their job to preserve it and turn it over, period. So, Hank Brennan in the Reed case has been patting himself on the back about how he's been bending over backwards to look for all the evidence and to do a review of the evidence and to turn over things. And he's been, really patting himself on the back for going above and beyond, which I don't think he did. Clearly, he didn't. Because clearly these videotapes have been out there for almost 3 years. And Michael Proctor knew they were downloaded within days of the incident. Michael Proctor had them. And I would argue, based on Buchanan's testimony, the DA had them as well. So you don't, and you don't get to hide behind, oh, well, we just didn't think they were important, or we didn't know we had them. We just didn't think they were important because they weren't important for our theory of the case. Of course, they weren't important for your theory of the case. They were exculpatory. They're not going to turn over things that are potentially exculpatory because they want to win. And that's the problem sometimes, is that our prosecutors have moved away from seeing their role as seeking justice and doing justice, and move toward it's about winning and it's about being right. And I think that that is somewhat of a trickle down from some of the political division that's going on in our country, and the attitude that I need to be right at any cost. And I think that is trickling down into our justice system. So now we have prosecutors who are saying it's not about doing justice. It's about being right. It's about winning and being right. And so we're not seeing prosecutors stand back and say, wait a minute, there's not enough evidence to support a prosecution here. We're not seeing prosecutors push back against law enforcement and say, if you want to bring this case, go out and investigate it like grown-ups. Pull up your big boy pants and go out and do a thorough investigation. Bring that back to me and then I'll look at it. But don't come here and ask me to bring charges against somebody when you haven't done your work. You haven't done your job. And, you know, I mean, when I worked in the prosecutor's office, that was a pretty common occurrence. It was a common occurrence for a prosecutor to say, I read your report. I don't think there's enough here for prosecution. I'm going to send it back to you and let you do some more investigation. If you turn up something else, let me know. But otherwise, I'm going to decline prosecution because I can't prove a crime beyond a reasonable doubt. And that happened fairly frequently in the prosecutor's office when I was there. But that was a long time ago. And what I hear now from my friends that are still practicing is that the prosecutor's office is way different than it was 25 years ago when I was when I was there. That there's a lot more of the mindset of we need to keep the DA happy, and the DA is happiest when we get lots of wins. And so it's about us winning and being right. It's not necessarily about seeking justice. And that's what we're all about here, is chasing justice. So I think we're ready for some questions. I know that we haven't gotten to a lot of the cases that are out there. There were a few developments in Corey Richens, the Courtney Clenny case. There was something going on. But to be honest, I just haven't had the bandwidth to do more than keep up with Reed and Delphi. Y'all asked me about the Mullins case, which is the corn rake murders. And I started to tune in on it. And procedurally, I really wasn't very clear, because it's actually a post-conviction action, but it's like they're putting the case on again. So procedurally, I didn't get deep enough in it. I will try and get deeper into that for 2 weeks from now, because I won't be here next week. Next week is a travel day for me on my way to Tucson for the Tucson Festival of Books. I am going to put information out on the YouTube community page, as well as in our Facebook group, about what's going on there. And I was going to do it last week, but I just recently got the emails about the panel discussions and sort of a little bit more information about who I'm going to be on the panels with, and the things we're going to be talking about. So I'll fill you all in on that in the community page and on the Good Lori Facebook group. And but next week I will be traveling to Tucson, and I also have a book signing in Phoenix it is through the library, and I'm also going to put the details up for that. So anybody that's in the Tucson area or the Phoenix area, please come and see me. The signing in Phoenix is going to be with one of the local bookstores. I think it's called Changing Hands. And there we go. And it is on St. Patrick's Day at lunchtime in the library. So I will get all of the details, times, locations, addresses, all that in our chat and on the community page for YouTube, so you all will know. And please come out and see me. I'd love to see some of you who I haven't had the chance to meet yet. Don't forget, CrimeCon is coming up in September in Denver. So if you happen to be in that area, that would be a fun thing to do. I don't think I'm going to have a table this year, a booth. I think I'm just going to spend lots of time wandering and chatting and enjoying the folks that are there and some of the seminars that are going on. I felt like I missed a lot last time. I got to meet a lot of people, and I met a lot of you while I was had a booth at CrimeCon and was kind of in a central location, was able to visit with people and able to hand out flyers for the book, all for the pre-orders for the book, all those things. But I felt like I missed out on a few things. I missed out on Summer Shiflett. She was there, and I wasn't able to attend her interview and discussion. And then I went to be on Bob Motta's show and Joel Waldman's show, I think, and missed her when she came by my table. So yeah, I think it's a lot of fun, and it's a way to meet all of the creators who are involved. So if you get a chance, think about that. And I will be in Boise for a signing with Rediscovered Books on the 25th. I think I still have a mistake in the show notes, and it says the 5th. It is the 25th, and I will go fix that right now. Jen's nodding at me. So, questions? I know y'all probably have some questions. Hi. No. The question is, hi, good Lori. Has Lori Vallow ever contacted you and asked for commissary like she did to Gigi McKelvey? No. And I wouldn't send it to her if she did. I reached out to her while she was still in jail prior to the trial, and she didn't answer. I did send a stamped, addressed envelope because inmates don't always have stamps. So I sent a self-addressed stamped envelope if she wanted to contact me, and I never heard from her. I did not reach out to her after the trial. I was on really short deadline to get the book finished, and after Chad's trial, and so I didn't reach out to either one of them. I think her interview on Friday will be interesting, but I expect it to be just as self-serving as she has always been. She's clearly narcissistic and has religious delusions, and she is going to go and espouse those delusions, and she's going to try and put herself in the best light possible because that's who she is. And so I expect it to be as self-serving as she's always been. I mean, you can't get more appalling than her doing an interview with Colby that she knew he would broadcast, and alleging that that Tylee was responsible for JJ's death and that she then took her own life. That's just absurd. It doesn't fit the facts. It doesn't fit anything we know about the case. And it's just incredibly self-serving and disrespectful and disgusting. So I expect that she'll continue to do that. So I think that one of the reasons she decided that she wanted to get rid of her lawyers was because she thought, because they advised her not to do this interview, and she wanted to. And I think it's all about just getting what she thinks is her story that hasn't been told out. So I think it's shocking that she's doing it 3 weeks before her trial on Charles Vallow's murder, but you can't fix stupid. So good question. What else y'all got for me? Hi, Beth. Can't something be done about these judges who are obviously biased? How is this justice? I think that's a really good question. It's even more troubling in states where judges are not elected, they're appointed. Now, my home state of Oregon, judges are elected. Now, to be honest, what typically happens is a judge, it's unusual for there to be a contested judicial seat. Often what happens is a judge retires or resigns midterm. The governor appoints a replacement to fill out that judge's term, and then that judge runs as the incumbent. But there is an election every 4 years for that judge. So the people do have an opportunity, if they feel that this judge has not behaved themselves or not been a good judge, there is the possibility that judge can be voted out. That's not the case in states that appoint judges. I believe Massachusetts appoints judges. I'm not positive of that. I know that South Carolina judges are appointed and not elected, but I believe it's that way in Massachusetts. I think Canoni is appointed. When it comes to Judge Gull, she's a senior judge, and she was appointed by the Indiana Supreme Court, or I think the Indiana Supreme Court, to take over this case. She is a special judge. I suspect that if Richard Allen gets a new trial, there is enough to keep Judge Gull from hearing it a second time. If Karen, we're seeing that Karen Reed's is going to get a new trial, and it's going to be right back in front of Judge Bev, Auntie Bev, or as Melanie Little calls her, Lady Macbev, with the out down spot. So yeah, it is a frustration. I know that in South Carolina, since the Murdoch case, there has been a move to change the system in South Carolina so that judges are no longer appointed. Because what happens is you've got this group of lawyers who are also legislators, and they're the ones who sit on the judicial appointment panel, and it's all very incestuous. It's you scratch my back and I'll scratch yours, and you get me appointed to the bench and I'll help out here. And it's a very dishonest and politically driven system. And I know that there is a move afoot to change it in South Carolina so that judges are elected. Because I do think that when judges are elected, and they do have to stand for election, even if it's a system like ours where it's unusual to have a contested election, it is possible. And that threat of there being a contested election is often enough to sort of keep judges on the straight and narrow. Knowing that in 4 years you have to get reelected, and that if people are dissatisfied with you, there's possibility they could they could sponsor somebody to run against you. That's not a great proposition if you are sitting on the bench. So, yeah. Now, I will say there are a lot of judges who will claim that they are underpaid, and in some states they are. And you have to look at it and say, okay, judges are making a pretty good salary in the grand scheme of things. But if they were lawyers working at their full capacity, they could make a lot more. That's always an argument. I think that for the most part, judges are pretty well compensated. I think that we have a horrible problem when it comes to public defense and the way that it's paid for and the way that public defenders are compensated. And that continues to be a problem, continues to be worrisome. In my own state, in Oregon, now that I'm back in Oregon, we continue to have a terrible shortage of public defenders. Young people coming out of law school are not going into public defense because they can't support their families and pay their student loans on what public defenders are making. For the most part, they're private contractors, so they don't have retirement fund, they don't have health insurance, that's all things they have to provide for themselves. And that's a lot to ask. So a lot of younger people are just not going into public defense. And the unfortunate part of that is that sort of naturally weeds out the good, talented people and leaves the less skilled and less talented as public defenders. And that's sad. It's sad for defendants who are relying on those people and whose lives are in their hands. So I hope that it will get better, but with what's going on right now in our country and the cuts that are happening across the country to federal programs and federal employees, I don't hold out a lot of hope. I think it's going to get worse before it gets better, unfortunately. So, shouldn't there be oversight for judges like the bar for lawyers? Yeah, I wish there were. Now, in many states, there is a judicial fitness commission, which is appointed in my state, it's appointed by the Chief Justice of the Supreme Court. So in my state and in a lot of states, the Chief Justice of the state Supreme Court is also the chief legal officer of the state. Okay. Now, we also have attorneys general, and they're sort of the legal counsel for the state. But it is the Chief Justice of the Supreme Court that oversees the court process and oversees judges. So in my state, the Supreme Court has appointed a judicial fitness commission, and that commission does review complaints about judges and does review judicial fitness in general. So there is a mechanism for state court judges to be held accountable. That commission then makes recommendations to the Supreme Court, and the Supreme Court makes a decision on whether a judge should be disciplined or whether a judge should be their appointment should be terminated. So it doesn't happen often, but it does happen. We have had instances in the past where we have had judges who committed how do I want to say that? They committed infractions of the ethical canons that judges are required to comply with. And in some cases, it could be criminal. In most cases, it is sort of judgment and ethical sorts of missteps. And oftentimes the Judicial Fitness Commission is also looking at judges who potentially have health problems that are interfering with their ability to do their job on the bench. There certainly have been occasions where the Judicial Fitness Commission has said, we need to have a mental health or a competency evaluation done on a judge because it appears that their mental acuity may be impacted by health issues, dementia, those sorts of things. So, I mean, it does happen, and certainly because we have an aging population. We have an aging bar. I mean, it's amazing how many old gray hairs are still out there practicing. There are a lot of 70-year-old lawyers out there still practicing. And, you know, I mean, there's a break point because you really want someone who has a lot of experience and has been there, done that, seen it all, probably has forgotten more about the law than most people know. You want that person to be your lawyer, but you also want the person who's got the emotional and the physical and the mental stamina to try a Karen Reed case where you've got this incredibly complex case and these juggling and keeping all those balls in the air. So, you know, I mean, I think that it's most important that every lawyer sort of look at themselves and say, I know where I'm at. And I know, you know, I for myself, I felt like I had reached the point where maintaining the caseloads that we were required to maintain was getting away from me. Now, does that mean I felt like I wasn't a competent lawyer? No, not at all. But I felt like the level of caseloads that I was carrying, I just wasn't comfortable that I was keeping all the balls in the air the way that I expected from myself. So yeah, I mean, you do get to the point of being burned out and being overwhelmed by your caseload, and sometimes that happens, and it happens with judges as well. So that's a good question. As I'm rambling, anybody got a last question before we wrap up? We're right at the 2-hour mark, so unless there are any last questions, I'm going to first of all thank Jen, as I always do, for being a wonderful moderator, and thank all of you for being here with me tonight. I appreciate you all being here. And, you know, I know that you have other things that you could do with your Wednesday night, and I know that there are other creators out there that you all watch. I watch them too. So it's great when I have the opportunity to visit with you guys. I am still very excitedly pursuing a new project. And when I am to the point where I can tell you all about it, you all will be the first to know, because you've all been there with me as we've done all this. So I appreciate you being here tonight. Thank you so much. I hope that you enjoyed it. And if you have questions that we didn't answer, please drop them in the chat or email them to me, and we will answer them. I try my best to answer questions as they come in. So you can always email them. That email is info@thelorivallowstory.com, at least for now. And or you can drop them in the comments here on YouTube. So with that, I'm going to say good night. Have a great week. I will enjoy being in Tucson next week. So I will see you in 2 weeks. If something really earth-shattering drops, we might do a surprise live. But so be sure that you've hit the notification bell, and please like and follow us. Good night.